Welcome to LexDiscuss Cafe, the podcast where we dive deep into the legal world, unraveling complexities, and shedding light on fascinating legal stories.
This is your host, Avinash Tripathi, and today we have a remarkable guest joining us, Mr. Abhishek Nema. He is a seasoned legal expert with over a decade of experience, and he has worn multiple hats in the legal arena. From practicing law in the High Court to becoming an in-house counsel, Abhishek has done it all. He is not only adept in legal subjects, but also an efficient manager, keen observer, and an amazing negotiator.
But that's not all. Abhishek isn't just about legal jargon and courtrooms. In his spare time, he transforms into a wordsmith, a Hindi writer who weaves poems and stories. Yes, you heard that right. Legal documents by day, lyrical verses by night. So whether you're a legal enthusiast, a curious mind, or simply someone who appreciates the power of words, this podcast episode promises to be a delightful journey. Buckle up as we explore legal intricacies, unravel our guests' unique experiences, and maybe even sneak in a poetic line or two. Without further ado, let's start this podcast.
So, Abhishek, thanks a lot for joining the podcast. It has been a privilege to host you as a guest.
Thank you so much, Avinash.
It's completely our pleasure. So, let's jump right in. What motivated you to shift from practicing in High Court to becoming an in-house counsel? And how has your courtroom experience shaped your approach in the corporate legal world?
So, Avinash, frankly speaking, my first love was litigation.
Okay.
So, when I moved after the college, I started to practice before the Jabalpur High Court and the other district court in the Madhya Pradesh High Court. That I decided during my law college that I will practice, I will go back to Madhya Pradesh and I will start practice there. Then I joined a chamber of relatively young lawyer who was having a decent number of cases being handled by him. And during my litigation practice, what I realized, legal world is not as same as we are told in the college. I noticed that the client prefer more experienced lawyer. They do not care from which college you have passed out. And if you are the second or third generation of a lawyer family, you will have their own client from the beginning. But I am the first generation lawyer. So what I realized, it will take me another 5 years to get a name in the bar where I will have my own client with decent money. So I need some money in backup to survive for these 5 years. But unfortunately, what happened, my father had to take VRS due to the health issue. And it was not too late that I asked him to send me more money for next 5 years. So that time I got an opportunity with Ruchi Soya Industries Limited. I interviewed there. They were looking for some trademark attorney. And during my college, I worked on some IP matters during my internship. So I got selected. And this is the way I came into corporate legal work. So it is basically not motivation. It was the circumstances because of this I came into corporate legal department.
Wow, such an honest response. And quite true, the experience that you had is experienced by a lot of lawyers who join litigation.
Who join litigation and then turn it into the in-house counseling.
Right.
And now coming to your second question, the courtroom experience helped me to certain extent in the corporate legal work. See, when you join in-house in some corporate legal, the first thing my first was told me कि भैया आपको अपनी जो वकालत है वो ऑफिस के बाहर छोड़ के आनी पड़ती है. Okay, but what helped me, that is, I learned two things during my litigation practice. That was the client counseling and finding the right to bench.
Okay.
When I was working in-house counseling, so what we are supposed to do? We are supposed to gather and collect information from the internal stakeholders of the company whenever the legal problems comes.
Right.
We need to counsel them. So the skill that I learned from my senior for the counseling, I utilize there in the in-house role. And you have a problem and you have filed some court cases. You need to find out what is the mood of the judge. See, a lawyer knows the law and a good lawyer knows the judge. This is the basic fact. So we keep patience whenever we appear in the court with our external advocate. We first try to find out what would be the mood of the judge today. And if we think that something is going unfavorable, we try to delay the things. And whenever we find the right judge, or we think that now the judge may pass some order in our favor, then we put our case. So this is the two things that I learned during my litigation practice. And the third most important thing, that is the drafting thing. So when I joined my senior in litigation, I was drafting from the first day because I learned drafting during my internship in the college. So when I joined in-house role, what was the trend that time in Ruchi Toya and also in most of the company in around in 2011 and 12? The in-house counsel used to work as a postman between the external counsel and the company. They were giving all the information to the external counsel and every work being done by the external counsel. But I realized that I can add value to the company in this case. So what I started, I was given mostly the trademark portfolio. So I observed how my external counsel was dealing for the matters. And then I suggested my boss, why not I can start filing trademark application from my own. I can start drafting opposition, counter statement, and the affidavits on all things which are related for the trademark practice. And we hire the external counsel only in case of the hearing.
Okay.
That helped me a lot to grow in the organization and improve my work. And you want to believe, after 1 year, I got 52% increment in the organization.
Wow.
That is the thing.
Congratulations.
Yes.
Right. I completely understand that must be quite rare.
Yes.
अभिषेक, बहुत ही अच्छा लगा आपने एक ऑनेस्ट स्टोरी शेयर करी. एंड जो पोजीशन में आप थे कि 1-2 साल प्रैक्टिस कर रहे हैं लिटिगेशन में एंड देन यू सी कि यार अगर मैं फर्स्ट जनरेशन लॉयर हूं तो मुझे 5-6 साल तो लगेंगे ही लगेंगे. And then you see a transition from litigation to a corporate role or at least a role where you're earning a living wage. So, जो लोग अपने आप को इस पोजीशन में पाते हैं उन्हें क्या करना चाहिए? How should they approach this?
See, first and foremost thing, you should read as much as law you can.
Okay.
Either you find out some good senior who can pay you well and at least the minimum wage. And if you're not paying, you can think about moving to the in-house because the in-house company pay you that decent salary in the beginning, but you need to crack the interview. So for that, you need to get the knowledge of law. So I always suggest people to come prepared in an interview with the legal knowledge. If you don't have legal knowledge, no company will entertain you.
Very wise words there, Abhishek. When you say legal knowledge, are we supposed to memorize all the bare acts? Are we supposed to keep updated with the latest judgment? Are we supposed
It is not the case.
principles? Right.
It is not the case.
So can you be a little more specific as to when you say you should have a legal knowledge, what exactly that knowledge is?
You should have the basic knowledge, basic concept you must know. You should know what is the, if we are talking about the law contract, you must know what is the free consent. If the free consent is not there in the contract, what would be the outcome? What is the liquidated damages? What is the representation and warranty? So these are the basic concepts you need to know. How the documents are exhibited. These are basic concepts. You need not mug up the section. You need not remember the section number. Even you do not need to remember the title of the case law. Only you need to know what is let down in that particular case law.
Exactly. Because when you need, you can always do a little bit of legal research and find.
Yeah.
So in your experience, what are the best sources to gather these basic concepts?
See, generally what I do, there are some legal articles are there. There are books are there. So whenever a problem comes, what I do, I read the provision. I read the commentary of that provision and find out some cases. When you read the case, you find some other cases. And this is the way your knowledge will enhance.
Wow.
And so this is the only thing that you can do.
Reading as much you can, right?
You have to read anything.
Right. As long as it's not a magazine or something on Instagram, right?
No. Even if you're reading a magazine, you can get some good content from there also.
Right.
That can be useful in future for any of the dispute or any of the legal problems that you face in your day-to-day life.
Right. But if it is a legal magazine, I'm talking about like there are
not only legal magazine. See, we cannot read the legal things always. You will get irritated, you will get bored.
Right.
So sometimes you have to read something that you like.
Yeah.
So you will get the habit of the reading because of that.
Absolutely. I agree. Like if you are in that phase where you don't even have the habit of reading, just read anything, right? Just build that habit. And once you have inculcated the habit of reading, then start to focus on, which are like, core to your subject or the thing that you're trying to master. And one of the things that I have experienced in my professional career is that, there's a very specific reason that we have to do a graduation before doing law. So you need to have some kind of understanding of how society, how history works, what has happened in the past 200, 300, and 400 years to kind of understand why these laws are the way they are. So if you are in that habit building phase, what I'll say, reading history books or political science book or even philosophy, everything will help you.
Yes. As you think that Roski Point had said, lawyer is a social engineer and you need to balance the different interests of the society. So you need to know first what the society is.
Very well said. Moving on to the next question. You have mentioned that you are a community mediator. Can you share an experience where your skills as a community mediator were crucial in resolving a pre-litigation dispute?
First, I discussed what is this community program.
Right.
So, during the first phase of the COVID-19, somewhere in June 2020, NP Salsa, they thought that they need to tell some members of different community, different parties, so that they can resolve the dispute between their community members at the pre-litigation stage itself. And our community, that the Nema community, was one of them, and we were the first. We were the pioneer in that. So around 20 people from my community, from them some were the advocates, I was the in-house counsel, and there were some social workers. They were given 20 hours training of mediation. Generally, to become a mediator, you need 40 hours training, but we were given a short training of the 20 hours. That is the case. And after that, we established the pro bono mediation center in different cities in the Madhya Pradesh. So what happens whenever there's a dispute and people know that the community has a mediation center, they approach us. So what happened, there one case, one of the community members, he was having a restaurant. And during COVID-19, what happened, that his business was affected and he could not pay his staff. So naturally, the dispute arose between the owner of the restaurant and the staff. And the staff threatened that if you do not pay, I will go to the police. This is the thing that the normal people will do. And that person came to us and we told that we can resolve your dispute if provided your staff also comes to our center. And fortunately, the staff also came. Then we consulted both of them. We had a talk with them. We arranged in the mediation, generally both a joint session. When you conduct a session in front of both the party and there is single censor. The single session, you meet one party at one time. So in single session, what we came to know that the result of the dispute is something else. It is not the case that staff we were not paid. So what we came to know for last 3 years, the owner did not increase the salary of the staff. So that was the actual reason that we came to know in the single session. Then we talked to the owner and told that whether you want to retain the staff or not. He told that he very much needed the staff because of the COVID-19 situation. There is a shortage of staff also. So then we told him that why don't you offer an increase in the salary? And if you increase, we think that we would be ready to serve you and he won't file any case or he won't take any action against you. He also agreed. We made a settlement agreement. And till now, I know that that staff is serving that restaurant. So this is the way that when you mediate, you will find out the actual reason of the dispute may be something else. And something else is presented before the forum. If you go in the normal course, you will get the outcome what you present to the court. You won't get the actual remedy that you are looking for because it is never the case. The lawyer will hold your case according to the law and according to their convenience. But in the mediation, you will find out the right remedy and that can be fruitful and long-serving for your business and for your all these.
Wow, very great insights there. Now, let me ask you a fun question. If animals could pursue legal careers, which species do you think would excel as litigators and which animal be suited for an in-house counsel role?
This is something really I think there are what we call the fox. The fox are very much suited to the litigation thing because they are cunning, they know each and everything. And if you think about the in-house, it would be elephant that would be suited for the in-house role.
Wow, they're diplomatic and have a great memory. Great answers there. Abhishek, we all know that you have extensive experience. Since you graduated from law college, how have you observed the legal landscape evolve, especially in India?
If we see in India, we have borrowed all the concepts from the English system. The court system that we are following, that is all given by the Britishers. And before Britishers, we were having our own panchayat system. So the Britishers developed the system for their own convenience. So not सब अपने लिए किया, because the people were agitating against them. So उन्होंने क्या किया कि that establish a support system where you can punish the people.
Okay.
But when we got the independence, what we did, we copied all the systems from them.
Yeah.
Okay. So we were copying everything from them. We copied it, and then we did not think what is required to be suited to our present society. We did not think about it. But when we developed more, and also there is change in the government, you can see that when the Arbitration Act was enacted, so there are some more concepts that we were following from the long time. Even in 1996, we adopted some of the things from the 1960 Act. But when this 2015 and 2019 amendment came, you will see that in 2019, there is a concept of the Arbitration Council of India. Generally, what happens today, the arbitrators, when there is no agreement or after the dispute party do not agree, you need to approach under Section 11 before the High Court, and the High Court will appoint the arbitrator. And it is a time-consuming process. So in 2019 Act, there is a concept of the Arbitration Council of India and the Arbitral Institute, and there is a grading system. And now, if this is implemented, it is not enforced yet. The Arbitration Council of India has been notified, but it has not started functioning. So once this will happen, you need not approach under Section 11 to the High Court. हमारे पुराने टाइम में क्या होता था? There was a पंचायत system. So whenever the dispute occurred, क्या लोग वहाँ सीधे राजा के पास जाते थे और कहते थे कि साहब हमको एक पंच दे दीजिए जो कि हमारा डिस्प्यूट सेटल करे. There were society, there were body who were having their own punch. हम कहते हैं ना, this arbitration is the imitation of our old panchayat system. This is not exactly the case. That time there was separate body, there was separate community who were having their own punch and who used to pronounce the judgment which were obeyed by the people. And only in rare cases people were going to the king. That was the system. But what is happening in our system, the arbitration party approach to the High Court, and the High Court will appoint the arbitrator. So this is the thing that I think we need to redefine our law as per our needs, as per our system, and we need not blindly copy what had been given by Britishers to us.
Wow, very wise words. Great insights there, Abhishek. And you know, one of the things that I found really irritating when I was also litigating was that, you know, our insistence on wearing black suits in the hot summer of Delhi.
Why don't we ask me wear kurta and pajama? That will be the case.
Which is suited for the climate of our own country, right?
Yes. And one more thing, why we have English language in the Supreme Court and High Court. In the High Court, we can have the native language. In the Supreme Court, we can Hindi, or we can also have the other language. We say that the people in the South, they do not understand Hindi. So they also may not understand English because English is also a foreign language to them. Then why do not we adopt Sanskrit in that case?
Sanskrit, that's a controversial opinion.
That is a controversial opinion, but you can use English. It is also foreign language. Why don't you use the other language of the country?
Right. Exactly. And you know, some people from the South will argue that Tamil is actually older than Sanskrit. So Tamil should be the default language. But but it should be the Indian language. That's exactly what my point is, right? I don't care whether it is Sanskrit or Tamil, but it would be better than English. But unfortunately, that's not the case. So moving on from very insightful answer, we have been told from verified sources that you are really concerned about mentorship and knowledge sharing within the legal community. Why do you think it's so important?
See, what I think in the legal profession, nobody will teach you how the law is practiced. So it is not basically the giving lecture to the juniors and make them prepare for the legal problem. It is the mentorship. You have to mentor them, and how it can be mentored when you are a litigating senior. What you will give them the brief. Okay, they will read the brief and they will find out how you have drafted a particular case and how you have argued this before the court. And that you expect your junior, they ask some query, they ask the question, whatever they have, and then you satisfy them. Similarly, when I am in the in-house role, for example, there is a contract which has come for review to me, and I have given it to my junior that you make the first review, I will make the second review of it. So my junior has given certain point, he edited the document, and then what I will do, I will review it, and I will not tell what mistakes you have done. I will just reply to it and will ask my junior to find out what changes I am making. If you have any question, you can come to me. I will satisfy you why some of your changes were discarded or I further edited. So this is how the knowledge is transferred in the legal profession. So this is exactly the mentorship case. This is not that I am giving them lectures. What is this concept? What is that concept? That I presume that they should know and they should read by themselves.
Wow. You touched a very real topic. One of the things which used to baffle me a lot is the work culture that we have in litigation and law firms. Because you have seen that transition, and in a limited aspect, even I have seen that transition. Why do you think that's the case? Why litigation the juniors are treated so badly? Or is it just my misunderstanding that's not the case?
No, I tell you, one of the senior in the NP High Court, उनका कहना था कि शेर अपना शिकार कभी दूसरे को नहीं खाने देता. This is the answer.
हाँ, वो बात सही है. But
yes. So this is the thing, because they are also treated by their senior in that way.
Yeah.
आपके पापा ने आपको मारा, तो आप अपने बच्चे को मारते. This is the thing which is coming from the generations.
Yeah.
But now the things have started to change. I am seeing that some of the senior, they are paying not very good amount, but as per their arrangement, they are paying that they are able to meet the requirement. So this is the case. Now the trend is changing, and I hope that it will encourage junior to be in litigation.
Yeah. So do you think litigation has a worse work culture than an average corporate legal department in India?
See, the litigation work culture I'm talking about, when you are practicing as a lawyer, you will learn a lot.
Right.
As far as the legal things are concerned. But when you go into in-house, not only the legal thing, you will also learn the other thing. You will learn accounting. You will learn management. You will learn marketing.
No, that's absolutely fine. But like, it's about the learning aspect. I'm talking about the work culture. Like, I have seen firsthand that, किसी junior से कुछ गलती हो जाती है and उसका senior is literally shouting at him or her for that matter. But अगर आप किसी corporate department में work करते हो तो maybe आप पे इतना ज़्यादा pressure नहीं होता है. क्या ये सच है? ऐसा होता है?
Sometimes it is such, but by luck, my senior in litigation, he was not above me. So what happened in one of the case, he asked me to appear. There is a confusion, and I forgot on whose behalf I was appearing.
Yeah.
I did not mean anything. And what happened, that case was dismissed. Okay. Then my senior just told me that because of your mistake, this happened, but it happens. It is not a problem. But you need to be very careful in the future. They did not shout at me.
Okay.
But I tell you, there are some super senior in the litigation. They think that if they shout their senior, it will make their reputation. This is the case I have also seen. But when you are the in-house counsel, so your boss is also an employee. So company has a culture.
Yeah.
So then boss also has to be responsible to the management.
Yeah.
And it is very hard to find the resources in the market. The right resources. If you shout at them, there is always a possibility that you will lose them. So this is the thing that in-house, you have a modest work culture in comparison to the litigation.
Wow. Very real insight. Because, what used to happen, like when I was litigating or interning under some senior, so they will say, like, ये तो तुम्हें आना ही चाहिए यार. And even he knows and I know that ये कभी भी law college में पढ़ाया नहीं जाता. And अगर मुझे आ रहा होता, तो why would I be working with you for free? If like, कुछ साल बाद when I was hiring people for marketing role or for sales role, और मैं कहता था, यार ये तो तुम्हें आना ही चाहिए. Sir, ये आपका work culture है. As an organization, it is your responsibility to teach me, right?
Yes.
अगर आपने 2-3 बार सिखा दिया, उसके बाद मैं नहीं कर रहा हूँ, तो फिर कोई बात है. पहली बार तो expect ही मत.
पहली बार तो, see, even in the house now, when we have any junior commits a mistake first time, we accept them. The second time he commits, we will ask him to rectify it. But third time, when he commits, I will take a class. That is my work of it.
That's fair. That's fair. I can understand.
Yes.
So as we are running out of time, this is the time for rapid fire question. So the first one is, if you were a new addition to a color box, what color would you be and why?
It is the blue color because I like the blue color most.
Right.
And ये blue color है ना, ये आंखों को चुभता नहीं है. मैं भी नहीं चाहता कि मैं किसी की आंखों को चुभूं.
Well said as a corporate lawyer. So the second rapid fire question is, what's the funniest thing you have ever heard in your legal career?
Let me think about it. Yeah, that is the thing that you're working at in-house, and whatever drafting is coming to your company, whether it is a simple letter, people will come to you and they will seek your guidance and they will take your hand to write it down. This is the funniest thing that I always come across, but that is the thing we have to help them.
Okay. Next question is, if you could be any superhero, which one would you be and what would be your superpower?
I think you have read Chacha Chaudhary.
Yeah, absolutely.
Chacha Chaudhary का दिमाग कंप्यूटर से भी चलता है, तो I want to be Chacha Chaudhary, and I want that my mind should run faster than a computer.
The best answer I have heard on this question so far. So yeah, that brings an end to the rapid fire round. So we just have a time for one more question. Now the question is, what is the best advice or what is the best professional advice you have heard in your career so far?
This is the thing that I learned from my first boss, in which is why Mr. A.D. Rao, when he told that कि भैया आपको legal manager बनना है. So besides law, you also need to know how to manage the things, how to manage the people.
Yeah.
So this is the thing that besides law, we need to crack all over things. And you cannot be master of none being in a house, but you have to be jack of all trades.
Very wise words. So this brings an end to this podcast. Abhishek, thanks a lot for joining the podcast. It was an absolute pleasure.
Thank you. Thanks so much.
And that concludes the first part of our conversation with our guest. To our audience, remember that legal knowledge isn't just for lawyers. Today's episode serves as a reminder that the law isn't confined to dusty books. It's alive, evolving, and intricately woven into our daily experiences. As always, stay curious, stay caffeinated, and stay legally savvy. If you enjoyed this episode, don't forget to hit that subscribe button. You won't want to miss the second part of this podcast.
Also, don't forget to share and like to make the algorithm gods happy. This is your host, Avinash Tripathi, signing off.